thereafter, there was further demand of dowry, and she was ill-treated in the matrimonial home and sought for action against her husband and father-in-law under alleging the commission of offence under section 498A IPC, 498A, 506 IPC, read with section 34 IPC, and also under the provisions of section 3 and 4 of the Dowry Prohibition Act. First, on receipt of the complaint, Jaipura police conducted detailed investigation and filed charge sheet. First, after securing the presence of the accused persons, charges were framed and the accused persons were duly tried. First, learned magistrate Narsimrajpura, sitting at Koppa, found that prosecution evidence was not sufficient in establishing the charge and acquitted the accused number 1, and also noted that during the pendency of the trial, accused number 2 died. First, being not satisfied with the order of acquittal passed by the learned trial magistrate, state preferred an appeal before the district court, Chikmagaluru. First, learned judge in the first appellate court, in the light of the grounds heard on behalf of the state, reconsidered the material evidence on record and noted the principles of law enunciated in Chandrappa versus State of Karnataka, reported in dash, Chandrappa versus State. Concurred with the finding recorded by the trial magistrate that the prosecution evidence is not sufficient to record an order of conviction. Dismiss the appeal. First, next para. Thereafter, state is before this court. Next para. Lord HGP, Sri Channappa Irappa, HGP Purti Baribeku. Channappa Irappa, reiterating the grounds set in the revision petition, contended that both the courts have failed to note that material evidence on record is sufficient enough to establish at least the fact of payment of dowry, and on the said charge, accused should have been convicted. First, he also pointed out that the difference of opinion arose in the matrimonial tie, instituted, and mere grant of divorce between the revision petitioner, between the PW1 and accused respondent would not efface the criminality that occurred when PW1 had the matrimonial relationship with the respondent and sought for allowing the revision. Per contra, next para. Shri Umesh, lead counsel for the respondent, contended that accused is presumed to be innocent till the charges leveled against him stands established by placing cogent and convincing evidence on record, and such an order, first up, and whenever a duly constituted court records an order of acquittal, the innocence of the accused stands doubled, which has been rightly appreciated by the learned judge in the first appellate court, and therefore hardly there is any scope for interference of well-reasoned orders by both the courts in this revision, and sought for dismissal of the revision petition. Next para. Having heard the parties in detail, this court perused the material on record meticulously. Next para. On such perusal of the material on record, it is a fact that PW1 Ramya got married to the respondent at
5/4/2009.
Koppa, Veerabhadra Swami Temple, Koppa on 5/4/2009. First, however, on account of serious disputes in the matrimonial relationship, parties also approached the jurisdictional court and they are now separated by decree of divorce. First, next para. To establish the offence under section 498A, 506, read with section 34 IPC, the learned trial magistrate has recorded reasons that such ingredients which are necessary for proving the aforesaid offences have not been proved by the prosecution by giving cogent and by furnishing cogent and convincing reasons. First, in other words, prosecution case lacked necessary ingredients to establish the aforesaid offences. First, so also for the charge of dowry, there is no matter law on record. First, as per the Dowry Prohibition Act, customary gifts which are given in the marriage are to be excluded from the purview of the allegations whenever there is a demand of dowry, whenever there is a charge of demand of dowry. First, in the case on hand, no such material evidence is noticed by the learned trial magistrate, which was reconsidered by the learned judge in the first appellate court. Next para. Taking note of the above aspects of the matter and also taking note of the fact that the parties are separated by decree of divorce, this court in the regional jurisdiction.
Marriage date ಇನ್ನೊಂದಿದೆ 8/5/2009 ಅಂತ.
5/4 ಅಂತ ನಿಮ್ಮ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಕೇಸ್ ಇದೆ.
ಅಲ್ಲ ಬೇರೆ
8/5 2009 5/4 ಬೇಡಮ್ಮ 8/5 ಮಾಡೋದು. ಆಲ್ ರೈಟ್. ಲಾಸ್ಟ್ ನಲ್ಲಿ ಏನ್ ಹೇಳಿದೆ? Divorce, this court is of the considered opinion that the grounds set in the revision petition are hardly sufficient to.
ಇದು ಮದ್ರಾವತಿ ಟೆಂಪಲ್ ಅಂತಿದೆ ಮೇಲೆ 8/5.
ಅದೇನ್ ನೋಡಪ್ಪ ನೀವು ಅದೇನಿದೆ ನೀವು ಅನ್ನೋ ಹೇಳ್ತೀರಿ. ನಿಮ್ಮ ಐ ಆಮ್ ರೀಡಿಂಗ್ ಫ್ರಮ್ ಯುವರ್ ಜಜ್ಮೆಂಟ್.
ಇದರಲ್ಲಿ ಇದೆ.
Read the judgment, no? Read the judgment of the trial court.
Trial court ಪ್ಯಾರಾ ನಂಬರ್.
Yes, ಬಿಡಿ ಅದನ್ನ ಅಲ್ಲಿಗೆ. ಆಯ್ತಲ್ಲ? Following order, revision petition is meritless and hereby dismissed. It is your case. He has given the complaint and that has been extracted. How can we say something else? ಅಲ್ಲಿ ಏನಿದೆ ನೋಡಿ, ಓದಿ ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಓದಿ.
ಸೆಕೆಂಡ್ ಪ್ಯಾರಾದಾಗಿದೆ.
ರೀಡ್ ಇಟ್, ನೋ ಅಲ್ಲಿ ಕೊಡಿ ಅವ್ರಿಗೆ, ನಿಮ್ದೇ ನಾನು ತಗೊಂಡು ಓದಿ ಅವ್ರಿಗೆ. ಅವ್ರಿಗೆ ಕಂಪ್ಲೇಂಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಓದಕ್ ಕೊಡಿ ಅವ್ರಿಗೆ ಫಸ್ಟ್ ಪ್ಯಾರಾ. ನನ್ಗೇನ್ ಕನ್ಸು ಬೀಳ್ಬೇಕು ಯಾವ ದಿನ ಯಾವತ್ ಮದುವೆ ಮಾಡ್ಕೊಂಡ್ರೆ ಅಲ್ಲಿ ಅಂತ ಅದ್ ನೋಡೇ ಬರ್ದಿರೋದು. ಓದಿ ಅಲ್ಲಿ
ಪ್ಯಾರಾ ನಂಬರ್ 2 ರಲ್ಲಿ ಇದೆ.
ಅಲ್ಲಿ ಏನಿದೆ ಓದಿಪ್ಪ, ನಾನು ಓದಿದ್ದನ್ನ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ CW1 ರಮ್ಯಾ as their marriage talk was held 5/4/2009 at Veerabhadra Swami Temple.
ನಾನೇನ್ ಬರ್ದಿದ್ದೀನಿ?
ಒಂದು
ಆಯ್ತು ಬಿಡಿ. ಎಸ್ SV Prakash.
Number 38 SV Prakash.
Millard, answer there.
ಹೇಳಿ
Petition Millard. Millard, it is accused petition Millard.
ಹೇಳಿ.
The trial court, the offense alleged as 279, 304A, 337 IPC.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಶಿಕ್ಷೆ?
6 ತಿಂಗಳು.
ಮತ್ತೇನ್ ಮಾಡೋದು?
Fine. Millard, in this matter, 279, when I preferred appeal before the first appellate court, the offense under section 279 has been modified and it was set aside.
ಮುಂದೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಸೆಟ್ ಅಸೈಡ್ ಆಯ್ತು ಅಂದ್ರೆ ಮುಂದೇನು ಅಂತ?
Regarding other offenses, it has been confirmed, my lord.
ಆಯ್ತು, 279 ಮರ್ಜಸ್ ವಿತ್ 304A, ಅದಕ್ಕೆ ಸಪರೇಟ್ ಸೆಂಟೆನ್ಸ್ ಬೇಕಾಗಿಲ್ಲ ಅನ್ನೋದು ಕಾನೂನು.
ಅದಕ್ಕೆ ಬಟ್ ಅಲ್ಲಿ 304 ಗೆ ಕನ್ವಿಕ್ಷನ್.
ಮಿಸ್ಟರ್ ಮೂಲಿಮನಿ, ಪ್ಲೀಸ್. Whether the person died a natural death or because of the accidental injuries.
My lord, after getting the.
What is the PM report?
My lord, PM report marked through the IO, my lord. It is not admitted. Death is admitted.
ಒಳ್ಳೆ ಚೆನ್ನಾಗಾಯ್ತಲ್ಲ. What do you mean by not admitted?
My lord,
how much cost I have to impose and dismiss the revision? If you want to say
my
that.
Lord, my submission, my lord. He was discharged from the Mangalore hospital and he was admitted later he was admitted in Shumaga hospital, my lord.
No, nothing doing.
Thereafter, my lord, after the decision, the scene of accident was on 11/8/2016, my lord. He died on 28/8/2016 after discharge from the hospital, my lord.
Look at the opinion for cause of death, Mr. Mulimani.
Yes, my lord. My lord, I was not having a opportunity of cross-examining the doctor because doctor not examined the
What prevented you to
First-
make an application before the first appellate court?
that is a fault, my lord. That is a fault on my
ಮತ್ತೆ
part.
ಬಿಡಿ ಅಷ್ಟೇನೆ ರಿವಿಷನಲ್ ಜೂರಿಸ್ಡಿಕ್ಷನ್ ನಾವೇನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ನಥಿಂಗ್ ಡೂಯಿಂಗ್. ಬರ್ಕೊಳ್ಳಿ. ಹಾರ್ಡ್ ಶ್ರೀ ಉಮೇಶ್ ಮೂಲಿಮನಿ.
Even he has even my
ನೋ,
another
ಸ್ಟೇಟ್
one
ಅವ್ರು
speaker.
ರಿವಿಷನ್ ಹಾಕಿದ್ರೆ 1 ವರ್ಷ ಮಾಡ್ತಾ ಇದ್ದೆ.
ಅವ್ರು ಮಾಡಿಲ್ಲ, my lord.
ಅವ್ರ ಮಾಡ್ಲಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಅಡ್ವಾಂಟೇಜ್ ತಗೊಳ್ಳಿ. 6
ಮಾಡಿಲ್ಲ.
ತಿಂಗಳಿಗೆ ಸಂತೋಷ ಪಡಿ. What was your answer in the 313 statement?
It is total denial, my lord.
ಮತ್ತೆ?
It is happening. Universally,
ಮತ್ತೆ?
it is happening.
ಮತ್ತೆ
The importance of 313